Hello everyone, I'm Stick Sasha, and this is also Stick Sasha.
Hello!
And we're here today to talk to you about international law. So, first off, what is international law? From our handy dandy textbook, international law is considered to consist of the customs, treaties, judicial decisions, general legal principles, and sometimes the resolutions of the United Nations. It regulates matters such as borders, war, diplomacy, citizenship, and immigration, and for the most part, is accepted by other nations as binding in their relations to other nations. While there is the United Nations, one of the most dissimilar aspects of international law from domestic law is the fact that there is no authoritative legislative body making decisions about how everybody should behave. Because of this, interactions between different states are often regulated by treaties and covenants, a treaty being an official, express written document that states use to legally bind themselves. So, country A says that they will not build bombs if country B agrees to not build bombs, and they sign a paper on it. Everybody is happy. Another issue is that there is no outside group able to enforce the treaties between states or resolutions of the United Nations, making it a wee bit difficult to convince everybody to play nice when they don't want to. So, keeping this in mind, let's go back to the part where I mentioned that international law is, for the most part, accepted by other nations as binding. Domestic law is characteristic in that it binds citizens whether they like it or not. You can dislike the fact that you can't rob banks as a matter of course, but you're still bound by law not to do it. And if you do, there are consequences, sometimes really bad ones. With international law, however, if a country decides that robbing banks is allowed within their borders, there's not a whole lot that the other states can do about it. They can impose sanctions, such as the time the US decided to formally ignore Cuba and not give them any of their stuff. But other than that, options for coercion are very limited. So now that you have a basic understanding of international law, I'll pass you over to the other Sasha to give you some more concrete examples.
I will be talking about the European Union as a regional example of international law. So, community law, also known as European Union law, is a body of treaties and legislations. These can posit direct effect or indirect effect on the laws of the European Union member states. The legal structure which presides over European Union law is the European Court of Justice, established in 1952. This formed after World War II, when economic and security tensions were running high. Naturally, as so many countries lived in such proximity with one another, European states shared many common interests in protecting regional trade and security. It has been noted that since 1964, the community, comprised of member states in the European Union, constitutes a new legal order, neither a subordinate part of the laws of member states nor simply a subsystem of international law. In the legal world, this seems to be a reasonable amalgamation of similar bodies acting in a common interest. Sometimes it's not clear which level of law, i.e., community law versus domestic law, is to be followed. In 1989, a court decision known as Factor Tame showed that British courts recognized that community law prevails over state law. This has caused concern for loss of national legal identity. Areas of international discourse that community law directly or indirectly guides includes administrative law, social and market regulations, human rights, environmental law, free movement and trade, and taxation, among others. Another indirect benefit from a community legal system in the European Union is their shared currency. The euro is second only to the US dollar as the most widely traded currency, giving it validity and stability. Similar to American federal law, community law presides in a conflict between EU member states. This is useful in cases when states have an imbalance of power, as the European Court of Justice can impartially mediate a resolution. The Court of Justice of the European Union is the highest court able to interpret European Union law. The majority of community law is implemented by the authorities of member states at their own discretion. So basically, the member states of the EU voluntarily recognize community law and decide that community law prevails over their own domestic law in areas of contradiction.
Alright, so we have an idea of what international law is and how it works. Let's look at a critique of international law. We will be looking at H.L.A. Hart in this particular example. So for Hart, he was a skeptic of the legitimacy of international law. He challenged the validity of self-imposed international laws and noted that the traditional notion of the sovereign, i.e., a person above the law whose word is law to his inferiors or subjects, does not exist in the international arena. There is no way of knowing what sovereignty states have till we know what the forms of international law are and whether or not they are merely empty forms. Hart makes a threefold case against the obligatory character of the international law on states.
First, he says that these theories fail to explain how states can only be bound by self-imposed obligations, and stresses that simply because something is said enough, it should not be taken to be fact.
Second, he proposed that the absolute sovereignty of states is inconsistent with obligation of any kind, and that a state cannot bind itself. He sums up this idea by saying, in order that words, written or spoken, should function as a promise and give rise to obligation, rules must already exist providing that a state is bound to do whatever it undertakes by appropriate words to do. As states are the highest form of sovereign which exist in the international system, and they merely agree to cooperate with another, there is no governing body outside the states that can establish a rule to bind states to their promises. Hart sees this as problematic.
Finally, as modern law is primarily treaty law, it has been shown that rules which appear to be binding on states without their prior consent do, in fact, rest on consent, although this may have been only tacitly given or has to be inferred. In short, Hart is concerned with the notion of states establishing rules by which they themselves will abide, as this violates the validity of the rule. Canada's participation in the Kyoto Accord would be a great example of a current state agreeing to a rule that it established itself and then being able to walk away from it, thus proving Hart's point. It is interesting to note that Hart comes from the school of thought known as legal positivism, which has generally touted that international law is the result of acts of consent among sovereign actors, nation-states that make treaties and create international legal institutions.
So, with our look at Hart's critique finished, let's look at two of the philosophers we've studied in class and how they conceptualize organization of international law. We will start with our good old buddy Kant.
Kant saw value in establishing authoritative public institution beyond the domestic domain, but was certainly not in favor of an institutional world republic. Kant's ideal international organization was a league of states, empowered to make collectively binding decisions with regard to international disputes, since establishing such an authority is the only way in which one can avoid the subjection of state actors to the arbitrary choices of other state actors. An important aspect of Kant's League is that membership is voluntary, meaning that states can choose to enter or exit the League. Therefore, a state could base its level of power in relation to whether it exists within or outside of a coalition. Kant's notion of the relation between states is no different than Hobbes's interpersonal state of nature, which is a natural, constant, anarchic, and violent power struggle. In this view, it is reasonable that state governments would seek an overarching governing force, just as on the interpersonal level, we seek governing as a contrast to everyday chaos.
Habermas wasn't a huge fan of Kant's League of States. Similar to Hart, Habermas believed that there was fault in Kant's model of voluntary entrance and exit to and from and compliance with the League. Habermas noted that states would only have moral, not legal, obligation to comply with the rules of the League since the arrangement relied on the goodwill of members. Instead, Habermas proposed a multi-level institutional model that assigned different tasks to different levels. Contemporary philosopher Jarton Michelson noted that compared to Kant's League, a reformed world organization has more extensive powers, with the main goal as the global protection of human rights, regardless of conflict. The defining feature of Habermas's organization is a mid-level between the supranational and domestic jurisdiction. This level is receptive to regional organizations, such as the EU, as groups with similar interests and the capacity for making decisions in the best interest of the nation-states within its borders. And with that, I would like to hand you over to Sasha with some amusing, to me at least, parting thoughts by contemporary philosopher Marty Kosciuszko.
States have tended to accept obligations only to international customs of agreement that either match what they were going to do anyways, or that are so vague and idealistic that their meaning or application in any given circumstance can nearly always be challenged and rejected by states which do not wish to comply. Thanks for listening, and we look forward to having a discussion with you about this.